Welcome to another edition of the Parliamentary Agenda, a program where we highlight the legislative activities of the government. Now, we have been on recess for quite some time. Nevertheless, we are back and we are excited to have this conversation with you. For this discussion, I have with me the Attorney General and Minister of Legal Affairs, the Honorable Mohabir Anil Nandlall. Minister Nandlall, thank you for joining me.
It's a pleasure to be here, and I'm happy to discuss the parliamentary business with you.
Yeah. Minister, now Parliament is set for November 7th, Monday, and a number of bills are on the agenda. Let us talk firstly about the Constitutional Reform Commission bill. Where does that bill stand? What are we to expect to happen on Monday? And if passed, what is the next step for that piece of legislation?
Well, we have articulated from the beginning of our tenure in government, taking from our manifesto, that we will have a very aggressive legislative agenda with the intent of modernizing the entire statutory landscape of our country as we prepare for the economic, social, and legal transformation that is currently ongoing. That process is continuing, and as you rightly indicated, we have a packed agenda come this Monday in the National Assembly. Part of our legal reforms include another manifesto promise of constitutional reform. Because constitutional reform is different from the statutory or other legislative reforms, it has to be treated separately. And why it is different? It is different because to get any article of any importance amended, modified, deleted, changed, or in any manner whatsoever altered, it requires a vote of 2/3 majority in the National Assembly.
Right.
That makes constitutional reform a special process and differentiated from the ordinary legislation, which can be passed by a simple majority. Significantly, all the parliamentary parties in their manifesto running up to the 2020 March 2nd elections committed to constitutional reform. In fact, the APNU AFC campaigned heavily on constitutional reform in 2011. They won a one-seat majority at those elections, as you will recall. They took control of the Constitutional Reform Standing Committee. They voted in then opposition leader Mr. David Granger as chair of that committee. And from 2011 to 2015, nothing was done in that committee, though that was a big ticket item on their manifesto. Fast forward 2015 to 2020, they went into government after the 2015 general elections. They assigned then Prime Minister Moses Nagamutu some type of special responsibility to deal with the question of constitutional reform. A small committee was established by Prime Minister Nagamutu, and millions of dollars was paid for that committee to do some type of report. The committee apparently did its work. It did not consult publicly, neither did it consult with the then major opposition party. But a report was apparently handed over to the then Prime Minister, and there was a huge Kodak moment in the newspapers. No one has seen the report since. You are a reporter. You have not seen it.
I haven't.
Neither has it been seen by, well, the Guyanese public. Then there was also a standing committee on constitutional reform headed by Basil Williams, the then Attorney General. Nothing of substance again was accomplished in that committee. So though it has been a big campaign promise for the coalition government since 2011, from 2011 to 2020, they had control of the parliamentary process, and they can show nothing towards constitutional reform. That's the backdrop to this bill. This bill was taken to the parliament, well, taken to the standing committee. The standing committee in the parliament called the Constitutional Standing Committee. We decided to use that as the committee to kickstart the constitutional reform process. That committee is consisted of government members and opposition members. We had great delay because the opposition members either refused to turn up or were not willing participants in the process. As I outlined earlier, constitutional reform requires both sides. It's a bipartisan process involving both the opposition and the government. One hand can't clap in this process. So I had to make, as chairman of that committee, several adverse public statements about the behavior of the opposition in the standing committee. Eventually, we got the bill out. Fortunately, it is a consensual product. What the bill seeks to do is to establish a broad-based constitutional reform commission, very much like its predecessor of 1999-2001. 50% of the commission will be made up of government and parliamentary opposition, and 50% of its membership will be drawn from civil society organizations representing labor, religion, private sector, the legal profession, the indigenous people, youth, and women. These are all, hopefully, will be politically neutral persons. So you will have a commission that has a unique admixture of politicians and the society coming together to work.
So just so I understand before you continue, Minister, so the first 50% is government, the first 50% will comprise government and opposition within that 50%.
That's correct.
And
That's
then
correct.
the other 50 has the other. Okay, good.
That's correct.
Good.
The chairman of the commission will be appointed by the president. The commission will regulate its own business and will determine how its agenda will be planned and how the agenda will be executed. Importantly, however, the Commission will, in accordance with the terms of the Act, be mandated to hold public consultations across the country. And from those public consultations, recommendations will be extracted, discussed by the Commission, refined, agreed upon, and put forward as proposed amendments. This bill will be read a second time and debated, and read a third time, and will be passed after after Monday's sitting. After that, the President is expected to assent, and the bill will become law and can become operationalized with every convenient speed thereafter. The process of appointing the commission, of going out and getting nominees from the various organizations, the President will have to appoint the chairperson, a secretariat will have to be established and staffed, expertise will have to then be retained to constitute support base for the commission. So a lot of preparatory work will have to then begin once the bill becomes law. And that hopefully can begin with every convenient speed after the bill receives the assent of His Excellency the President.
So we have a clear understanding of what is going to happen in relation to the constitutional reform bill. Now, Minister, there are two bills that I believe are concomitant or go together, in my opinion, which would be the Motor Vehicles and Traffic Act Amendment Bill and the Intoxicating Liquors Bill. Now, remind us of what those bills seek to do and what is the government's position as it relates to those matters in terms of what it seeks to do and hopes to achieve in the near future.
Fatal accidents caused by road traffic accidents, fatalities rather, resulting from road traffic accidents have always been a huge problem in our country. We have a small population, a young population, and without fail, in any given week, we have several road fatalities resulting from vehicular traffic accidents.
Right.
The level per capita in Guyana is unacceptable, and this has been a problem dating back decades. Any analysis of the statistics will reveal that driving under the influence of alcohol is a significant contributor to these accidents, including non-fatal accidents. Any responsible government faced with the current array of statistics, both fatal and non-fatal, must react to such a phenomenon.
Of course.
Our government has decided to act. One may criticize us by saying that it took us a long time. That may be so, but we are acting now, and we are acting decisively. The bill will introduce some very harsh measures in our law. Not only are they going to be harsh, some may consider them highly punitive. Some may go to the other extreme and say oppressive. And they are also unprecedented. But I believe that when one looks at the gravity of the situation, the magnitude of the problem, the stunning statistical data, then these measures, in my view, are completely justified. Before I get to the measures, we embarked upon public consultation. We posted this on Facebook. The president himself led the way. I put it on my public page as well. And I took the care and time to go through the comments. And I cannot recall, both on the president's page as well as on my page, reading negative comments worthy of remembering. Both pages that I looked at and the comments numbered in the thousands preponderated with support, widespread support. The Guyana Road Safety Council issued a statement in support of the bill. I believe other organizations in the country may have done similarly. So the measures, as I said, seem to enjoy public support from all indications. The first set of amendments seek to amend the Road Traffic Act. And they create an offense for the first time, a specific offense of causing death while under the influence of alcohol. The original legislation, or the current legislation, has causing death. This is a new case, that is a new charge that is being instituted. One of the components or ingredient of the charge being under the influence of alcohol. And then you have fatal and non-fatal. If you are under the influence of alcohol, driving, and you commit a fatal offense, mandatory imprisonment. Number of years, right? I think no less than 7, between 7 to about 15 years. Then heavier penalty if you're a repeat offender. Then if you're driving under the influence and you make an accident but it is not fatal, then you have a different penalty. I can't remember the exact penalties now. I invite members of the public to look at the debate. All of that will be coming out. And significantly, quite apart from the jail sentence and the huge fines that these offenses will carry, there is going to be put in place, in a very rigid way, a system that will disqualify you from driving from the moment you commit the offense, from the moment you are charged. A suspension regime will begin. If you are a repeat offender, then you are going to be disqualified. If you are a repeat offender and convicted, you are going to be disqualified.
From driving ever again.
From driving for protracted periods, number of years. Now, these were not measures that were hurriedly arrived at. You had to take into account whether you are violating a man's presumption of innocence by imposing what can be described as a sanction even before conviction. then one had to look also at the fact that some of these drivers are taxi drivers or minibus drivers, and driving is their livelihood and the method by which they sustain themselves and families. So these measures, as drastic as they may appear, were thought out, discussed, and clinically examined. What is more important? Having one man right to earn a living on the one hand being affected if he decides to drive drunk, and if he's driving a minibus, exposes 16 persons in that bus to exposing them to fatality or serious bodily harm, possibly maiming and disfiguring them. How do you weigh the balance? This bill weighs the balance in favor of the safety of those 16 persons as opposed to the right of this one man to continue to earn a living driving when he has been convicted by a court of drunken driving. You have 16 persons, you may have 16 breadwinners in there too.
Yeah.
Where do you strike the balance? Do you protect the one man and perish the 16 and their extended family? This legislation says no. You take the... So that's how those things were arrived at. The truth of the matter is that we have to change the culture of our people. We have to change behavioral patterns. We have a history of alcoholism, of heavy consumption of alcohol in this country. You have a history of and a heavy prevalence of driving under the influence of alcohol. You have a history supported by statistical data of the destruction of human lives and the destruction of human bodily parts through accidents caused by drunken driving or persons driving under the influence of drugs and alcohol. You simply cannot continue like this. And we have to begin the process of reform and rehabilitation now.
Yeah.
This is the beginning. This is not the end. This is the beginning. And this can be the only measure that we will pursue to address what is obviously a fundamental societal ill. Legislation can only go a certain way. We have to have public awareness. We have to have education. We have to have parents discussing with their children. We have to have teachers in the school speaking to students. We have to have organizations, religious organizations, social organizations, humanitarian organizations, carrying out a joint and several national awareness program and campaign. This legislation will obviously play its part, and it will stand as an example to what will happen to you if you violate the law. The next bill that accompanies that one is the Intoxicating Liquor Licensing Bill. In your opening remarks, you correctly draw a nexus between the two, because there is a connection between the selling of alcohol and its consumption. So, Guyanese are now a widely traveled people. They travel to jurisdiction across the world, in particular in North America and Europe, North America in particular. So they're very well aware of the strict laws in those countries. and the rigid enforcement of those laws. Yet when they come home, and when they go there, they adjust. And the Guyanese who go there to live, they adjust. But when they come here, they transcend into a completely different human being, and they do what they wish. Well, this law is to bring regulation and to establish a statutory regulatory framework. So this bill deals with the selling of liquor to drunken people or persons who appear to be drunk. And it creates a serious offense if one does that. Then it mandates the bar owners to put up signs at conspicuous places advising against the consumption of alcohol, in particular if you're driving. And it prohibits the sale of alcohol to a person who is a known driver or who has a vehicle within the precincts of the premises. It is a duty now that is imposed, that will be imposed on the liquor license holder or the holder of the liquor license. He may lose his license in the process, and or he may go to jail as well. He has a duty and a responsibility under the bill to inform the police if he sees that a drunken man is going to drive. So, a new dispensation is being established in this bill, a new slew of responsibilities which perhaps never existed in our country before. Now, let me say that I am not oblivious to the fact that enforcement of these laws are going to be a monumental task. It has not escaped my attention growing up in the rural areas of Guyana and dwelling in the rural areas of Guyana, the difficulty that bar owners will have when they attempt to execute their duties under the provisions of this bill when it becomes law. But as I said, we have to start somewhere. And the legislation is not a bad place to start. But it is only a start. Bar owners must understand their role. Guyanese must understand their role. Their role not only to protect themselves, not only to obey the law, but their duty to the public.
Of course.
You can't drink to such an extent that you and your motor vehicle become a lethal weapon on the roadways of this country, massacring and killing people in the process, maiming and crippling people in the process. And the society must stand idly by and allow that state of affairs to perpetuate for years. This bill, I believe, is a fundamental step forward in addressing what, as I said, has been and is a long-standing problem in our society.
Thank you so much, Minister. So very important information coming out there for the general public. Minister, I want to touch a little bit before we conclude on the restorative justice bill, and I want to ask, in reference to this particular bill, is the legislation involved in line or in keeping with international standards when it comes to restorative justice? And what are some standout points in the proposal that Guyanese can look out for on Monday coming?
So, restorative justice is a concept that is already well ensconced in first world jurisdictions. It is relatively new to the Caribbean and it's brand new to Guyana. It is the first time that we are introducing in a formal statutory way this concept into our criminal justice system. So restorative justice has to do with this softer approach to crime. It has been discovered by criminologists and sociologists and other persons who carry out these social surveys or surveys in the social sectors that the traditional approach to crime has not been as successful as one would have expected. Brutal, punitive, draconian punishment has not necessarily worked, has it?
No, it hasn't.
For the past 200 years, crime has increased rather than decreased.
Escalated.
We started out with chopping off people's bodily parts, hanging them publicly, star chambers, torturing people to death, cat o' nine tail, stroking people, solitary confinement, beating, flogging on the law books.
Yeah.
All those draconian, some may describe as inhuman treatment, have been tried. And the crime situation is with us, perhaps in a more pronounced way than it was 50 years ago. So that's not working. New methods are being tried. Concentration now is being put more on the rehabilitative, reformative, restorative side of punishment. So in the part of our agenda is training people, educating people in the prison system, in the penal system, so that when they come out, they don't come out as parasites and as persons incapable of earning a living and becoming a burden to society and eventually going back to prison because they simply can't survive. So you have that taking place, training, education, vocational training, etc. Then you have on the other side, finding out the real cause of the crime. Why is this man beating his wife? Why did this young man who has such a bright future resort to alcoholism or cocaine? Why this strong, trapping man, strong, big man, ably built, beat to death a man who can barely walk? These are not usual human reaction and conduct. Something triggered. There's something maybe of some degree of immediacy, or it may be something that is of some vintage. Restorative justice is to go into the cause, the under factors, right? The root problems. What were the factors that operated, that led to this conduct? As I said, it may have happened since childhood days. So the man who beats his wife, when you go and examine why, his father used to beat his mother. The cocaine addict, may be that he's molested in his house by some elder person. When these persons who are charged with committing these offenses appear in the court, they serve a term of imprisonment if they plead guilty or they are found guilty, and they go straight back to the place where the problem is. So they go back to the molestation. They go back to that environment that precipitated the delinquent, illegal, unlawful output in the first place.
Right.
And you have a cycle. This is intended to go in and find out. So this bill sets up an infrastructure where you will have a director, you will have a secretariat, and they will execute programs under the bill. We have already begun countrywide training across the length and breadth of Guyana. We have gone into the Amerindian communities or brought the Amerindian leaders to Georgetown, and trained them, all the 2 shows. We went to various counties or various regions, and we have trained different strata of community leaders. We have trained teachers, for example, because the school environment may be one of the fertile ground where these diabolical issues are formed and fermented. The formative mind is an absorbing one. So teachers are being trained and will continue to be trained to be able to detect the symptoms and to apply restorative justice right there in the school. So a child comes with marks of violence on his body, physically visible to the teacher. That teacher will have a duty to interrogate the circumstances that led to that output, because right there you have a potential possible either criminal or victim of a crime. So these are very modern, progressive, social directed concepts that have proven to be effective in other societies, and we are bringing them now as a part and parcel of our legal system. As I said, it's new. The public awareness and the training exercises are ongoing, and they have started long before the bill came into being. So we have done a lot of work, but a lot more has to be done. Journalists, you have to play a very important role in edifying and educating the society about these concepts. So when we set up the Secretariat, for example, obviously we will start in Georgetown, but it can't be that the entire infrastructure will be resided here, because you want to ensure that these centers are right across the country. The journalists and the media will have to work with these organizations to PR this concept, to educate people about these concepts, because as I said, these are very new concepts that we are introducing for the first time. So I'm very proud of this initiative, and I have a personal interest in pushing this agenda to ensure that this finds itself in every nook and cranny of our country. All the state apparatus, state organs must play their role. And that is how we will address crime in a fundamental way. Not reactionary, because largely our system of crime fighting is reactionary. Somebody get robbed, we run down the road trying to catch the man. Somebody thief, we try to find the thief. But we can start on the other side of the spectrum and do preventative crime fighting, where you attack it even before it starts.
Mm-hmm.
This is one of the concepts. This is one of the methodologies through which we can pursue that form of crime fighting. So that bill will also be debated in the National Assembly.
Minister Nandlall, one specific bill found itself in the Special Select Committee of the National Assembly, and that was the Narcotic Drugs and Psychotropic, I believe, amendment. Where is that bill now? What is the next step for that, and some updates as it relates to that particular bill as we wrap?
That bill has exited the Special Select Committee. Mm-hmm. The Special Select Committee completed its work, and that bill is in the National Assembly now and will be among the bills that would be debated for the Monday sitting.
Right.
The significance of that bill is that it removes custodial sentence from persons found in possession of 30 grams and below of marijuana. Being in possession of 30 or less grams of marijuana continues to be a criminal offense. What this bill does is that it removes custodial sentence. Prior to this bill, a person would have been sentenced to no less than 3 years and no more than 6 years were that person to have been found in possession of 30 grams of marijuana. That is no longer the case. I want to make that very clear because people believe that marijuana through this bill is now legalized. That is not so. We live in a complex society, and as legislation, as legislators, and as a government on the whole, we have to ensure that we arrive at positions that strike delicate balances between competing interests in a society. You can't please all the people all the time, but at least you should try to please most of the people most of the time. So you have the country virtually divided into two halves on this matter. One half will tell you, legalize it. The other half will tell you, don't touch it. In fact, increase the penalty. A responsible government must be able to bridge that divide. This bill seeks to find that fundamental balance. Hence, we have come with that formula. It may not be pleasing to everybody, but it is the best that we can do in the circumstances. Certainly, it is better than having our young men, in particular, and women, being put in jail for 3 years to 6 years for a spliff.
Yeah.
Whether we want to accept it or not, people smoke marijuana in Guyana. Middle class, upper class, lower class. Marijuana is now legal in Canada for own use, in several states in the United States, and in several countries in the Caribbean. That is the reality around the world in which we live. We can't be blinded to that reality. We can't be blinded to a whole movement called the Rastafarian movement, who believe, whether rightfully or wrongfully, that this is a natural herb created by some divine force. One can't turn a blind eye to the proven medicinal values that is attributed to marijuana. One can't turn a blind eye to a section of our country's population whose religion involves or includes the smoking of that substance. And there is in the Constitution freedom of religion. The same way that I am a Hindu and I want to have my prasad and my 7 curry, that marijuana is what is considered important as part of that religion. Then you have the other extremity, where people are telling you that it damages the brain, that it destroys lives, that it destroys families, that it is highly addictive, and with addiction comes vagrancy and destruction and violence and stealing and more crime. All of those, you have to strike a balance. And this bill, we believe, in a sensible way, strikes that balance. The other government, the opposition, they promised this, remember?
Yeah.
They even put a bill in the parliament and did not have the fortitude to take it forward. We have done something. We have tackled the bull by the horn, and we are putting something forward. As I said, it will never meet the expectations of the divide, but it seeks to bridge a gap. It seeks to create a median between the. Last thing in terms of penalty, so you wouldn't have custodial sentence.
Right.
What you will have instead is between 15 to 30 grams, you have community service, and from 1 to 15 gram, you have mandatory counseling. Right?
So it's not decriminalizing per se. It's not decriminalizing per se. So, Minister, just so we can confirm, so there were no major amendments or changes that were made within the Special Select Committee on this particular bill?
No, we looked at the Caribbean, we heard from many organizations, we heard from a large block of the religious community representing the major religions of our country. Of course, we heard from the Rastafarian movement and the various organizations representing the Rastafarians in the country, and we heard from other different organizations, and we tried to cull from both sides or from all sides and arrive at a position that accommodates. I can tell you that up to now, it is still a vexed and contentious issue, even as it appears in the bill. Right.
Well, we're looking forward to those discussions that will happen on Monday. Minister Nandlall, I want to thank you so much for taking the time to have this discussion today.
It has been a pleasure, and I hope that I have assisted your viewers in understanding some of the basic elements of the bills that we are going to be discussing.
Of course. The National Assembly convenes on Monday. Be sure to check any live stream to be a part of that process of legislative discussion at the highest level in our country. My name is Shaquan Gill, and this is me saying bye for now.